In the litigation between Blake Lively and Justin Baldoni, Lively's lawyers announced last week that they were serving some subpoenas on phone companies for a lot of phone information records from Justin Baldoni and his alleged quote-unquote co-conspirators. At first, it wasn't totally clear just how much this was, although Baldoni's lawyer Brian Friedman did respond publicly with a comment saying, essentially, that it was overbroad and a fishing expedition. Since then, the two parties have filed letters to the court over the issue, and after seeing the arguments fleshed out, we can see a bit better what's going on here. So in this video, we're going to get into what this whole dispute is all about, what the arguments are from either side, and why I personally think that these subpoenas probably should be limited. Let's get into it. So for starters, by the time this video comes out, I'm sure the judge will have likely already ruled on this issue anyway. But even despite that, I wanted to make this video because I think it's worth explaining what's going on here. There are a lot of people interested in all of the twists and turns of this case, and because of that, I want people to have a better baseline understanding of a lot of these different processes that are part of this litigation, so you can develop your own opinion from here instead of having to rely on the opinions of, say, journalists or influencers. And I also want to say that it does take time for me to produce all of these videos, from the researching to the script writing to filming to editing, etc. So there's usually going to be a lag of at least a couple days on any of these topics that I cover with this case. So if you want to see my thoughts on the latest developments of this case and also other legal topics as well, be sure to follow me on X, click the tab for notifications, and you'll see more there. I'm much faster at responding to things there, and I also do explain things, but sometimes it is easier to explain things in more detail in a video format. So with that, let's dive into it. Okay, so as I said before, Blake Lively's legal team released a statement to the press that they had served subpoenas on basically all the major phone companies in the United States for phone records belonging to Justin Baldoni, Jamey Heath, and others. Now, before we get into the details of these subpoenas and what this whole fight really is about here, let me first start by explaining basically the background of what subpoenas are and what the whole process looks like. But before I do even that, I have to thank this video sponsor. This video is sponsored by Saley. Saley is a new eSIM service app brought to you by Nord Security. It allows you to choose from several affordable eSIM plans in a growing number of countries and regions. If you're planning on traveling internationally anytime soon, you'll probably want to keep your phone data connected when you are overseas. Because there are a lot of places that have Wi-Fi, but there are also a lot of places that don't. And I can tell you from experience from living overseas for the last 4 years that it's not fun when you find yourself without both Wi-Fi and data. My phone plan from back home from the United States actually does give me a certain amount of data in most countries, but it's still not that great. I've had times where I've needed to, for example, take Legalbytes to the doctor, and on the way there, try to get authorization from the insurance company, but then in the midst of all of that, getting throttled by my phone service. Or maybe I don't need to talk to the insurance company, but I would like to know the fastest route to the doctor with my navigation app. And when you're dealing with a baby that's sick, the last thing that you want to be worrying about is your phone connectivity. But with Saley, I don't have to worry about any of that. After I downloaded Saley once to my phone, I just had to choose a plan that works for me. Super easy. And when choosing a plan, I can go with a specific country or I can choose a regional plan. And the next time we travel to another one of the 180 plus countries Saley serves, I can just purchase another package of data and use that while I'm there. My data won't get throttled, and Saley will give warnings when I've used 80% of my data package, so I can figure out if I need to buy more. So if you have a trip coming up, check out Saley either by scanning the QR code on screen or by following the link in the description below, and use the coupon code Legalbytes for 15% off. And thanks again to Saley for sponsoring this video. Okay, back to the video. So let's talk about subpoenas generally. I've talked about this in previous videos, but when we get to the discovery phase of litigation, there are different types of discovery requests. There are interrogatories, requests for admission, there are document demands, and there are depositions. Now, when discovery is being requested or demanded of an opposing party, basically all you have to do is just serve those discovery requests on them, and they're required to comply within a certain amount of time. And note that none of this is filed with the court in any way. That's because courts want to stay way away from the discovery phase of litigation as much as possible. It's just way too cumbersome of a process for the judge to be involved in. And courts are also just way too busy managing not only this case, but a bunch of other cases in their docket. It's not until the two sides get into a discovery dispute that they involve the court with something like a motion to compel discovery. But even still, the court wants to see that the two sides really did try to work it out amongst themselves first, because like I said, courts are super busy and they don't like having to referee every single little argument that comes along in the litigation and the discovery process in particular. Now, when it comes to these discovery disputes, know that as a default, the parties are entitled to a lot of information from one another. The standard for a discovery request is that a party is entitled to information not just that they think is going to be admissible evidence, but that will reasonably lead to admissible evidence. That means information that's related to either proving your claims or your defense or disproving the other side's claims or defenses. So, for example, if you've alleged something like intentional infliction of emotional distress, you are likely opening the door for the other side to be able to request your medical records. That is so that they can try to disprove the claim that you have been emotionally harmed. But although discovery is super open, it's still not limitless. You need to have some kind of reasonable justification for the information that you're seeking, and the information that you're seeking needs to be proportional to the needs of your case. That means if complying with your request would cost the other side a ton in terms of time, in terms of money, in terms of privacy, but what you're getting out of it isn't really that important to your case, the court might say, okay, technically this is relevant, but you're not entitled to this, or at least I'm not going to allow you to go this route to get this information because it's not really all that crucial for your case. And this is just having the effect, really more than anything, of abusing the other side with this request. And this is especially the case if there also are other less intrusive ways of getting the same or similar information. Now, all of that basically covers essentially discovery involving the parties in the litigation. But when you need information from someone or an entity that isn't a party, that's a third party, you need to serve them with a subpoena. So if you need records of someone's financial transactions, you might need to subpoena the bank or a credit card company or something like that. Or if you need medical records, you subpoena a hospital or a doctor's office. That's how you get those kind of records typically in litigation. And note that like the other discovery tools, subpoenas are not filed with the court. So the only way that the public really learns that a subpoena has been served is because there's either a dispute about it that the two sides can't work out, and so then they're filing motions to compel or motion to quash, or because one of the sides or maybe both of the sides have gone and talked about it to the media. Anyway, when you serve a subpoena on a third party, you also have to serve notice of the subpoena to the opposing counsel so that they can know what kind of information you're requesting and basically the process that you're taking. Then when the third party and the opposing party have been served with the subpoena or the notice of the subpoena, the third party has up to a certain amount of time in order to comply with that subpoena. Now, several things can happen at the point when that subpoena is served. First, the third party can turn back to the demanding party or the requesting party, and they can tell them, no, we have an objection. We have a problem with this, and here's why. And if the party making the demand disagrees, and they and the third party entity or person can't really work out amongst themselves what's going on here and why it shouldn't happen, the party demanding the subpoena can file a motion to compel discovery. Now, a motion to compel is pretty much exactly what it sounds like. You are filing the motion to the court asking them to compel the other side to produce the discovery responses or to produce the information that you're requesting. Now, on the other hand, the third party can turn and say, sure, okay, we'll give you these documents, whatever. In my experience in civil litigation, the latter is usually what happens. Now, at this stage, there's another thing that can happen. Remember how I said that the opposing side also gets notice of the subpoena? That includes copies of the subpoena, which details the scope of the information that's being requested. Now, the opposing party can also go back and tell the demanding party, the party that served that subpoena, hey, we have a problem with this, and here's why. Maybe it's an entirely improper subpoena for some reason, like the demanding party actually has no business requesting any information from this person or this entity. Or, and this is the more common alternative, the opposing counsel has a problem with the scope of the subpoena. In other words, the opposing party turns to the demanding party and says, you are requesting way too much here, and here's why. So when the opposing party objects in this way, they and the demanding party, the party that served the subpoena, they have to do what's called a meet and confer conference. At the meet and confer, they're supposed to essentially meet up and try to talk it out and to see if they can resolve their dispute. This usually means a phone call between the two lawyers of the two sides, where each one lays out their arguments as to why they think that the scope is proper or why they think that the scope is improper. Then the phone call is usually followed up with emails between the two sides that basically confirms everything that they talked about. That one side said this, the other side said that, and this is where they ended up. This is mostly so that they can have a record of what their conversation was, just in case they have to bring it up to the judge. In my personal experience, most of the discovery disputes that I've ever handled have actually gotten resolved at this stage, like the vast majority of them. But sometimes they don't. And when that happens with regard to subpoenas in particular, the opposing party files what's called a motion to quash. That is basically where you are filing a motion to request the judge to quash or somehow limit the requests that the other side can ask for. And the thing about a motion to quash is sometimes you do need to act fast, faster than you would for a motion to compel other discovery requests that are just between the parties. And that's because while the third party has basically a deadline by which they have to comply, there isn't like an earlier deadline where they can't comply sooner than a certain date. In other words, this third party might say, hey, I really don't want to get into any kind of trouble with the court. I don't want to miss any kind of a deadline. So I'll just give you these documents right away. Here you go. And if we're talking about a potential disclosure of private information, that is something that as a lawyer, you really need to protect your client's interests over. And you need to do it closely and quickly. Okay, so that's subpoenas in a nutshell generally. What happened specifically in this case? So last week, Lively's lawyers Ezra Hudson and Michael Gottlieb, I hope I'm pronouncing their names right, told reporters that they had served subpoenas on various phone companies. In the process, they said Miss Lively has initiated a discovery that will expose the people, tactics, and methods that have worked to destroy and bury her reputation and family over the past year. And they said, we will now receive all of the receipts, quote unquote, that unsurprisingly are nowhere to be found on Mr. Friedman's website. And like Miss Lively, those receipts, quote unquote, will have their day in court. In response, however, Baldoni's lawyer, Brian Friedman, countered that they are asking for every single call, text, data log, and even real-time location information for the past 2.5 years, regardless of the sender, recipient, or subject matter. This massive phishing expedition demonstrates that they are desperately seeking any factual basis for their provably false claims. They will find none. Now, it's not surprising to me that the attorney on the receiving end of discovery would characterize those discovery requests as a phishing expedition. That's typical for a litigator to call it something like that when they have some kind of an objection to it. It doesn't necessarily mean that it actually is a phishing expedition. So when I saw the initial back and forth, I wanted to see the inevitable filings on this if and when Baldoni's lawyers decided to file a motion to quash the subpoenas. And sure enough, we very quickly got a bigger picture of what was happening. On February 14th, Baldoni's lawyers filed their motion to quash via a letter that they submitted to the court. In it, they argue that the scope of the subpoenas is overbroad. Specifically, they said that the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history. And they said this implicates all kinds of information that they're clearly not entitled to, including communications that are covered by the attorney-client privilege, the marital privilege, medical information, and more. Now, if that's the case, if this accurately describes the scope of these subpoenas, there are a number of reasons why I agree that this is actually overbroad. First, Lively would actually be entitled to basically all of the communications between the parties about issues and events underlying this whole litigation. In fact, she's entitled to communications with basically anyone about these topics, except for spouses, lawyers, clergy, that kind of thing. Communications which would otherwise be privileged. But she's not entitled to all communications that these parties have had with anyone about anything over the last 2.5 years, because that is too much of an intrusion into the lives of these individuals. And what their family plans for Thanksgiving are, for example, it simply isn't relevant to this litigation. So that's why a subpoena needs to carve out limitations by saying things like, we're requesting all documents that you have pertaining to communications between these two individuals about XYZ between these certain dates. But if a subpoena just says, give me everything you have for this phone number, no matter who they talked to or what they talked about, that is going to go beyond what's necessary for Lively to fully litigate her claims. Now, the day after Baldoni's lawyers filed their motion to quash, Lively's attorneys responded, and they basically had three arguments. First, they said that Baldoni's lawyers mischaracterized the scope of the subpoenas. They said that they weren't requesting any substantive communications, only numerical logs of when 15 individuals called and texted each other, as well as location data. Now, looking at this, I will say that if in fact it is that it's just numerical logs that they're after, Baldoni's lawyers don't really have so much of an argument about the whole privileged communications thing. That's when they were referring to the attorney-client privilege, the marital privilege, medical documents, etc. And if Lively's attorneys really have limited the subpoenas to 15 specific individuals that they've determined are necessary for Lively's case, and they outlined those individuals in the subpoena's scope, then this does sound more like an appropriate subpoena. However, I do still have questions as to how the location data really fits into what Lively needs in order to litigate her case. That is an incredible intrusion into the privacy of all of these individuals, so there has to be a really good reason as to why Lively says she needs that. And her reasoning really should say why she can't get similarly good enough information to satisfy that through a less intrusive path. Now, the second reason that Lively's lawyers give for why the motion should be denied has to do with the meet and confer process. Specifically, they said Baldoni's lawyers didn't fulfill the meet and confer requirement, and on that basis alone, they said that the motion should be denied. They point to the fact that Baldoni's lawyers filed their motion to quash as quickly as they did, and so Lively's lawyers are basically accusing them of already planning to go ahead and file the motion regardless of what happened during the meet and confer. In other words, claiming that they didn't meet and confer in good faith with the other side. Now, I will say when it comes to this particular argument, it probably depends on the judge and the judge's preferences as to whether this argument will be successful. Like I said, judges generally don't like being pulled into discovery disputes prematurely. Some judges really are sticklers about that kind of thing too. With a judge like that, if there's more that can be done to try to resolve the issue first, you had better do it before you pull in the judge to act as a referee. But then other judges aren't necessarily as bothered by it if they think that the lawyers who filed the motion are at least acting in good faith. And here, personally, I think Baldoni's lawyers have a legitimate reason to be concerned about waiting too long before filing their motion. Like I mentioned before in this video, when it comes to third parties disclosing information, you don't have control over them. That's because they're third parties. So if they decide to disclose all of that information immediately, you can't stop them except for through this specific process. And it bears repeating that when we're talking about private information, any kind of information that is protected by the attorney-client privilege, by the marital privilege, medical information that is not relevant to this particular case, etc., you as the attorney have a duty to protect your client's interests. So if you have that conference call, that meet and confer with the opposing side, and opposing counsel during that meet and confer says, just flat out, no, we are not going to budge on the scope of this subpoena, and that's that. That could be enough for you to have satisfied the meet and confer process. There's no specific amount of time that really needs to pass before you decide that this is an emergency that you need to bring up to the court. And here, Lively's lawyers did say, hey, if the phone companies produce these materials immediately, we agree not to look at them until we all finish this whole meet and confer process. And their point is to say, hey, you won't have any harm in us having anything because we won't have seen anything until we've resolved this. But here's the thing. They were very specific in what they were saying there. They did not say that they were going to refrain from looking at the materials until the discovery dispute was over. They said that they were willing to refrain from looking at them until after the meet and confer process was over. And that is a small portion of the overall discovery dispute potentially. So let's say hypothetically Baldoni's lawyers agreed to that and said, okay, fine. If they disclose it, just don't look at it until the end of the meet and confer process. And then the two sides kept going back and forth over a number of weeks to work things out. Then if AT&T and T-Mobile and whoever all else produced these documents in the process, and then eventually Baldoni's lawyers decide after a certain amount of time, after these documents have already been produced, but no one's looked at them yet, but Baldoni's lawyers then decide, okay, you know what? We're not getting anywhere here. We need to file a motion to quash with the court and move forward with this. According to what Lively's lawyers are offering here, Lively's lawyers can then start looking at the documents once Baldoni's side decides to file that motion to quash after they finish the meet and confer process. That's totally backwards, because then you have Baldoni's lawyers saying Lively's lawyers shouldn't have this information. Meanwhile, Lively's lawyers are already potentially browsing through all of this information. So really, that's not much of a comforting offer by Lively's lawyers here. Anyway, the final argument Lively's lawyers make is that they say that the information they're requesting is in fact proportional to the needs of the case for two reasons. First, they say these records will provide objective evidence on when and how the defendants and witnesses learned about Lively's harassment allegations. And second, they say they'll provide objective evidence on whether, when, and with whom the defendants coordinated efforts to discredit Lively through the press and social media. I still don't see how the location data does that, but that's their argument. But like I said before, if the subpoenas in fact do state that they're limiting the information requested to communications between these specific individuals, these 15 individuals, and all they're looking for is like data logs as opposed to substantive communications, then they might actually be entitled to this. However, on February 16th, Baldoni's lawyers filed their own reply to Lively's lawyers, and this, I think, is very important. In their reply, they actually quoted what the subpoenas demanded. And according to Baldoni's lawyers, the subpoenas demand all documents concerning ingoing and ongoing calls or text messages related to basically the phone number owned by the person, including but not limited to call logs, text logs, data logs, and cell site location information. So everything I just said about Lively's lawyers specifying that this is limited to information about communications between 15 individuals basically is out the window. This is way, way more broad than that based on the language that's actually on the subpoena. This now looks like they actually are asking for all information about all of the parties' communications totally unlimited. And that's not a proper discovery request, in my opinion. Also, where it says that they're requesting all documents, that means that they're not just requesting phone logs or data logs. That means literally all of the documents that these phone companies have related to these phone numbers. Also, this subpoena says that they are requesting all of these documents, including but not limited to call logs, phone logs, text logs, data logs, and cell site location. So when a lawyer writes including but not limited to, what that means is I specifically want these documents, but if you have other documents that also kind of generally fit this definition, I want you to give those over to me as well. In other words, it's an incredibly open-ended phrase to include in a request like this. And that broadens the scope of what it is that they are requesting. So to me, the part that really gets Lively's lawyers into trouble here is this all documents and the including but not limited to language. Altogether, it really means that these subpoenas really are requesting basically everything that these phone companies have. Not just phone logs or text logs as they've described them in their letter to the court. So between that and the whole location data issue, which I still don't understand how the potential relevancy of that information to Lively's case outweighs the severe intrusiveness into the lives of these individuals. Between all of that altogether, I really think that Lively's lawyers need to trim back on the scope of these subpoenas before they should be complied with. And hey, maybe by the time I get this video out, the judge will have decided and he will have thought completely differently from me. Maybe there's something new for me to learn here. But at the moment, that's how I'm seeing these things. And those are my thoughts. What do you think? Is there a good faith reason that you think that they might want location data for all of these people for 2.5 years? Do you think it's reasonable to ask for that? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.